specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Hello to you all. You're welcome to today's edition of Hanging Out with BWF Solicitors. I hope you are all doing great. It's so nice to come your way again today. And today's topic is focusing on the child who has indefinite leave to remain if that child can register to become a British citizen. As usual, this program is all thanks to BWF Solicitors, and my guest is Mrs. Eunice Achampong, who is a seasoned solicitor and also a partner at BWF Solicitors. Please share this program on all your social media platforms. As you know, we are streaming live on Facebook, YouTube, and all other social media platforms. Please send in your questions, and myself and Lawyer Eunice will be able to, Lawyer Eunice is rather going to answer your questions. Share to all your friends. So let me quickly welcome Lawyer Eunice. Hi, Lawyer Eunice. How are you?
I'm doing well. How are you?
Right, I'm good.
Good.
How is the weather at your end? The way you are going sleeveless. I'm just.
I know.
Are you
sunny and bright?
Are you transmitting live from the Caribbean or something?
I really wish I was in a sunny island of maybe Jamaica or Barbados or somewhere. But at least we're here in London. It's sunny outside. I know the sun can be deceptive and it can be really cold, but I'm indoors, so I'm enjoying the weather indoors.
That's good to know. Laura Eunice, have you got any updates for us? For the week. I mean, what went on during the week? for our viewers, to be informed, if
Of
I should
course.
say.
Yes. So yeah, I think our viewers, and we are now in a new month. So happy new month to all of our viewers and those watching us on our different social media platforms. I think that during the past few, should I say, weeks, we've seen how the Russians have invaded Ukraine, and the UK came up with some concessions for family members who
Yeah.
are living in the UK who happen to be settled or British. And so those concessions have now been made into law. And you will find that under the immigration rules, um, most of the concessions in regards to the family scheme. So if you're a Ukrainian national, so specifically to Ukrainian nationals, if you are a Ukrainian national and then you are saying to yourself that you have family member here, either a
Mhm.
husband or a wife or a child, or it could be an adult relative that you have in the UK, and you are saying that you want to come to the UK because of this family member and because of what is going on,
Mhm.
you can apply for a visa to be able
Mhm.
to then deal with all the other things that come with it by the time the
Mhm.
visa is granted to you. They are trying
Okay.
as much as possible to make the process as easy as possible for the Ukrainian nationals who are applying. I know that in the news, there have been Ukrainian nationals who have even made these visa applications and haven't had any response. And so, as much as
Exactly.
possible, Priti Patel has made it an exercise for her caseworkers to be able to go through these visa applications and give the required response as soon as possible. And so that has been been made part of the immigration rules as of the 30th of March 2022. And then prior to this, I was saying last week and 2 weeks before how
Mm.
we've now had certain immigration rule changes, which now applies to our young adults who are between the ages of 18 to 25, who may have applied for leave to remain based on their private life. So if for one reason or the other you are between the ages of 18 to 25 and you've lived here for more than half of your life and you've made an application for private life and you've been granted 2.5 years, now if you are able to say that you have been able to live in the country legally for a 5 year period, after that 5 year period you can go ahead and apply for indefinite leave to remain.
Okay.
Whereas before, you would have had to complete a 10-year period to be able to apply for indefinite leave to remain. And then we have children who are born in the UK who age 7, or you are saying that because this child has lived in the UK for a continuous period of 7 years, maybe they are more than 7, and you have evidence that this is their birth certificate and you want to apply for indefinite leave for them, you can also go ahead and apply for indefinite leave after the
Leave.
6th of April 2022. So that is good news for our should I say, young people and children who have lived here for a continuous period of 7 years or have lived here more than half of their life and have managed to have leave to remain under the private life route, which I think a lot of parents who have 7-year-old children are waiting to make their applications will be glad to know that this route is also available to their children. So, in essence, because the child now has indefinite leave to remain, the parent will be able to get leave to remain. So, the parent is not getting indefinite leave to remain, but will be able to get leave to remain
Leave.
based on that child. That is also fantastic news. And
Mm.
I will keep reiterating that when it comes to the EA applications, I know there are some that made applications before the 30th of June 2021 deadline for EA applications. So if you made any EA applications or family permit applications, um,
Mhm.
now they have said that if you made any applications under that route, which was meant to be ending on the 30th of June 2021, they will
Mhm.
go ahead and issue EU settlement scheme family permits for those family members who were eligible to apply under the EEA route. So, as we all know, the EEA family permits are no longer um, valid, or they are no longer applicable. So,
Couple.
if anybody who has made that application for a family member is expecting that they will be issued with that EA family permit, they will have to be issued with an EUSS or EU settlement scheme family permit instead. And those that have gone to court to have appeals, of course, if their decision is allowed, they will be granted EU settlement scheme
Wow.
family permit instead of the EA family permit. So that is also good to know for those that made those applications before the 30th of June 2021. So, yes, in regards to our updates, those are the few updates that we have, and then I'm sure we can delve into our topic for today.
Thank you very much for those updates. At least there's something to look forward to. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors with your host, Vicky Newton. And our guest is lawyer Eunice Achampong. She's a solicitor at BWF Solicitors. And today we are discussing a child who has indefinite leave to remain. Um, can such a child register to become a British citizen? If that is so, Lawyer Eunice will also take us through what is required and what is needed, the necessary documents needed to put in such an application. Please share, 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 share. As you know, we are streaming live on all our social media handles, especially Facebook and YouTube. We would love to hear from you, so send in all your questions. Right now, Eunice, who is eligible to register as a British citizen under the British Nationality Act 1981?
So when we say who can register, usually registration has to do with children. When an adult wants to naturalize as a British citizen, we say they are naturalizing. So when we say register, we are referring to children.
Mm,
There are only a few exceptions where children, I'm talking about people who are 18 and above, may be able to register instead of naturalizing. And
okay.
one of those scenarios can be a child who lived their first 10 years of their life in this country. So if the child is now 18 or 20 and they can show that they lived the first 10 years of their life in the UK, they will still be able to register. And so when it comes to um, those that can register, we are mainly talking about children who are under the age of 18. And you would see from our British Nationality Act that there may be children whose parents are British or were settled before they were born. And so they would be able to register, I mean, they'll be able to gain British citizenship automatically. And then those whose parents were able to attain settlement or British citizenship after their birth will
Mhm.
then be able to register as British because at the time that they were born, their parents were not settled or their parents didn't have indefinite leave to remain or neither did they have um, any indefinite leave, like I was saying. So it's important to know that there will be situations where children will have to register because their parents or one of their parents did not have citizenship or did not have settlement at the time they were born. Yes.
Mm. Mm. But Laura Eunice, I remember you saying that if the child has, lived in the country for 10 years, does it include, a child's visit outside the UK? Let's say going for summer holidays once a year, or probably visiting twice a year. Does that add up to the 10 years?
So when we say somebody has lived in a particular country, I know that a lot of people would want to um, maybe give scenarios, for instance, where you go on holiday. If, for instance, you've been away for a period of time and you are thinking, what does it mean to live? So
Yeah.
if you're saying that you've actually lived in a country, you are really resident in that place. So that's where
Right.
you call home. So if that is where you call home and you don't spend half of your life somewhere else. So let's say that every 6 months you are in another country and then every
Yeah.
6 months you are in the UK.
Yeah.
So for the first 10 years of your life, you lived half in another country and half in the UK. Then obviously you can't really argue that you were resident here unless you have evidence to show that even though you spent those 6 months or half of your time in that other country, you still had things doing here in the UK. So it depends on the evidence that you can provide. But usually it means that you are resident here, you have things that go on here. This is where you call your home practically. So going on holiday is a usual thing that most people do. We are not talking about going on holiday, we're talking about where you are staying, where you actually call your home. Is that where you are resident? And if that is so, if you can prove that you have been resident in the UK for the first 10 years of your life, then yes, of course, you can go ahead and register.
Mm, mm. So,
Yeah.
can a child born outside the UK apply for registration if they have indefinite leave to remain?
So when it comes to the British Nationality Act again, it talks about children who are born outside of the UK, and you will have scenarios where parents may have been British, and because they were British before the child was born, they can go ahead and apply for a passport for the child straight away if the parents themselves did not attain British citizenship by descent. So what that means is that they didn't have their British citizenship passed on to them
Mm,
because they were
okay.
born outside of the UK. So once they have a child outside of the UK, maybe because they naturalized or their parent themselves were British and they also gained British citizenship through that way, that child who was born outside of the UK will be able to have British citizenship straight away. But then a child who has indefinite leave to remain, as our topic is focused on, will then have to be able to say that, yes, I have indefinite leave to remain. I was born outside of the UK, but because I've lived here for more than a period of 2 years, I have family ties here in the UK. My siblings are probably British, and my parents are probably British or settled here in the
Yeah.
UK. I
Yeah.
formed social ties here in the UK. My schooling and everything is here, and so I want you to look at all these ties that I have formed and then be able to grant me British citizenship. So that is a discretion that the home secretary or her caseworkers have under Section 3(1) of our British Nationality Act. So, yes, a child who has indefinite leave to remain and was not born in the UK can also register to be British. Yes.
Okay. So, how does a good character requirement apply to children?
So I know when we talk about naturalization for adults, a lot of the people are interested in the good character requirements because
Yes.
maybe
Yes.
they may have some traffic offenses. Sometimes
Yeah.
people may have some civil penalties, fines they haven't paid, and those sort of things. There are some people who are in so much debt that they even have to declare themselves a bankrupt. So
Bankrupt. Yeah.
all those things come up. And so when it comes to children, under the British criminal law, we know that a child who is age 10 and above is liable to commit a criminal offense. So,
Okay.
yes, when it comes to children, if the child is 10 or over, they would want to know if this child has committed any criminal offense whatsoever.
Okay.
Usually, you would see on the form MN1 whether this child has done anything where they would not be seen to have good character. They will ask for
Okay.
details of this child's school. And if, for instance, the child is 16, so for instance, at the age of 16, we know that children will get their NI given to them by the local authority. And then once they are able to work, they can start working. So some people finish their GCSEs and then they go off to work. They don't want to continue with their education, so they go off to work. And so if the child is working, they will have to put their employer's details on the
Yes.
form as
Mm,
well. Um, if they've gotten into trouble before, they have to disclose it, because one thing you don't want is for them to find out that this is
and
what you've
yeah.
done before you have stated it. So I always say that it's always good to disclose these things, because maybe it might be that for instance, you've committed an offense and they gave you a non-custodial sentence. So they didn't give you any sentence. They just said, pay this fine or go and do
Mm, mm.
this community service or
Community
whatever.
service. Yeah.
And you have been able to do that. There is leeway. So sometimes they may say, okay, give it some 3 years and then come back again and make the application and then we'll grant it to you. But if you don't disclose it whatsoever and they do find out, that's when it becomes an issue. But I mean, most of our children, we thank God that they don't get themselves into trouble. And so when it comes to registration, you do it as early as possible so that um, you prevent all these other issues coming up later on in life. And if for any reason your child has committed any offense and you don't put it on the form, that is also a criminal offense in itself for not disclosing it. So, as much as possible, the good character requirement comes in when a child is aged 10 or over and they ask all of the questions in regards to whether they've committed any offenses, whether they are at school or working, whether they've even committed terrorist acts, and all the rest of it is all on the form. So, to the best of your ability and to your knowledge, you must complete the form as truthfully as possible. Yes.
Amazing, amazing. Wow. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors. We've been talking about children who have indefinite leave to remain but want to register as British citizen. And with me is our cute, beautiful young lawyer, Mrs. Eunice Achampong. She's also a partner at BWF Solicitor. She's here with us today, taking us through this particular topic, what the requirements are, and also answer a few questions from you, our viewers. I am your host, Vicky Newton. Um, taking you through this program. Lawyer Eunice, I've got a question. I don't know why people don't want me to mention their names, but I'll respect that. This person says, I had my children here in the UK and was married to an EU citizen when I had them. I applied for my indefinite leave to remain under the EU settlement scheme and was granted in May 2021. I have not applied for the children, but would like to apply for them to be British. How do I go about it?
Okay. So I see that she's explained that she has indefinite leave to remain, but she was also married to an EA national. So there's the possibility that the EA national may have had permanent residence or may have had indefinite leave to remain even before the children were born. I don't know about that side, but if that is the case, then the children could be automatically British if the EA national was somebody who had settled status or had indefinite leave to remain or permanent residence
Yeah.
before the children were born. But if the EA national, for instance, didn't have indefinite leave or permanent residence at the time that the children were born, and it was after the children were born, um,
Mm.
she can choose to register the children. And so,
Okay.
in registering the children, they will ask for the parents' details and for her to provide evidence that she now has indefinite leave to remain or she now has settled status. And so they would request for those documents, for instance, documents that show that she has lived here for a continuous period of 5 years and under our former immigration EA regulations
Yeah.
2016, the EA national would have had to show that he was a qualified person. So if the EA national was a qualified person, they were either working or self-employed. So they would
Right.
have to show that they either had that permanent residence blue card or they had um, lived here and worked here for a continuous period of 5 years. And so that evidence will have to be provided to them for them to go ahead and register
Yeah.
those children as British. And so, if that is the case, then they will go ahead and then register those children to be British because their guidance, the Home Office guidance, is quite clear when it comes to EA nationals and their family members. So, uh, fortunately or unfortunately, they still have to provide evidence to show that they had
Mm.
permanent residence at the time the children were born, or if they are registering the children, which she is looking to do, then
Yeah.
she would have to show that yes, they had indefinite leave to remain and they had lived here and the EA National had worked here for that continuous period of 5 years before or after the children were born. And so she would need to provide all of those evidence and their passports. So if they do have valid passports, she'll have to provide that, including their birth certificates, their parents' documentations to show that they are settled here in the UK,
Okay.
evidence that the EA national either had permanent residence or had worked here for a continuous period of 5 years. And then they would be able to issue the children with their registration certificates.
Okay. All right. I've got Nana. Nana is asking. I would like to find out if my daughter who came from Ghana can register as British. She came with indefinite leave to remain. indefinite leave to enter and is currently 18 years old, can she apply right away?
So, in his daughter's case, she's come into the UK with indefinite leave to enter. Um,
Mm,
and once you are given indefinite leave to enter and you are in the UK, it's not saying that once the leave becomes invalidated, you no longer have indefinite leave. It just means that you would just have to now apply for a no time limit, and then they will grant you a biometric card that says that you have indefinite leave to remain.
mm,
In his daughter's case, he's saying that she came with indefinite leave to remain. He wants to know if his daughter, who is now turning 18, can now apply to register as British.
yeah.
Sorry about that.
Yes. Bless you.
So, if this child who is now going to turn 18 can show that she's lived here for 2 years, then she can go ahead and apply to register. If she
Okay.
hasn't lived here for a continuous period of 2 years or more, because their guidance is very specific. It's not under the law that they should look at this. That under section 3.1, because it's a discretion, there are
Okay.
certain factors that they look at when they look at children who can apply to be British. So I was mentioning that sometimes they look at things like their family ties, whether they have siblings that are British, whether
Yeah.
their parents are British or settled. They look at things like their social ties, whether they're in school or university, how they are integrating into British life, whether
Life.
they
Yeah.
really view the UK as their home. And so they say that within a period of 2 years, usually if a child is under the age of 13, they may, have built that um, integration here in the UK and those ties.
Okay.
And
That's
so when it comes to a child who is almost 18, it means that if they haven't lived here for that period of time, then they would have to then show
mm,
that they are now an adult and they will have to naturalize instead of registering.
okay.
Um, Once they reach the age of 18, then you will have to look at what the British Nationality Act says in terms of um, adults, children. I know that once a child is living under your roof, you still see them as a child.
Yes.
The law, unfortunately, says that from 18 onwards, they are no longer children. So now, if the daughter is going to be 18, the daughter now has to do the life in the UK test, do that English language test at level B1, will have, if the daughter has a qualification like an A level or a GCSE, which they now accept um, currently our immigration rules, because we know that from the changes that will be implemented from the 6th of April, anybody who has completed an A level or has completed GCSE will also be seen to meet that English language requirement. So it's not just the ESOL test or the undergraduate degree.
Mm, mm,
So if that child also has an A level or a GCSE, then they can use that as a means to say that they now qualify under the English language requirement. And then when it comes to showing that they have had indefinite leave for a period of 12 months, yes, they can show that, but they will also have to show that they have lived here in the UK for a continuous period of 5 years. So now it means that they will have to extend that period of time that they have lived here to 5 years
mm.
before they can actually make the application as an adult to naturalize. as a British citizen. So um, the age restriction can sometimes be a problem. So as soon
Mm.
as the child turns 18, now it means they have to meet the requirements as an adult rather than a child. And sometimes I know it can be expensive, but
Okay.
it's sometimes best. And the time is long-winded in terms of an adult application rather than a child application. So they may have to look at that as well. Yeah.
So, is the child, or should I say the teenager,
Mm,
apply by themselves, or the parents can do that for them on their behalf? Let's say an 18-year-old,
mm.
can he or she apply by themselves?
So if the child reaches 18, they are no longer seen as a child. So if they have to meet that 5 year requirement, they will have to show that they have lived here legally for that 5 year period,
Mm,
and then they can make the application. So if at the age of 18, let's say they've lived here only a year and a half, they
mm,
have 3.5 years to go before they can actually make the application.
mm.
Do you get it? So
Okay.
once they reach age 23, they can then make the application to be British or to naturalize as a British citizen. I mean, by that time, the child can do it on their own. But if at the time the child came into the UK, let's
Mhm.
say the child came into the UK when they were 16 and now
Yes.
they have indefinite leave to remain, I mean,
Right.
indefinite leave to enter, and they can show that they've lived here for a period of 2 years. Usually, by the time the 2 year period would have come, they would have turned 18, which obviously gives them that cutoff point. But if they came here when they were much younger and they were able to show that maybe I came here when I was 13, because I came here when I was 13, I've lived in the UK for a continuous period of 2 years. I've integrated into life here in the UK. The UK is my home, my school, and my friends are the people that I know. My family is all settled or British. And so by that time, the parent can say that I want to then register my child as a British citizen, and the
Mm,
parent can go ahead and make the application. But as soon
mm,
as they reach 18, that's where the cutoff point is. And then it's unfortunate that they would have to complete a 5 year period
mm,
before they
mm.
can then make the application to naturalize as a British citizen. Yeah.
Oh, okay. Okay. All right. Laura Eunice, how what can one do if the other parent refuses to sign the consent pages of the form?
So I know that usually when it comes to completing registration for children, it's one of those obligations that they request that both parents consent to the child being British. When it comes to registration, I know that there are some people who will say, maybe I can't find the other parent. What is your evidence that you can't find the other parent? There are some people who clearly do not have evidence of the father on the birth certificate.
Mm,
So if there is no father mentioned on the birth certificate, the home office or the um, department that deals with registration for children's citizenship cannot request any further evidence. They will just leave it as that because you do not know
mm,
where the father's whereabouts.
yeah.
Uh, but when it comes to, let's say, parents who have been in the system and they know that, well, the parent is mentioned, why can he not sign? Or why is it that the parent cannot consent? You have to be able to provide evidence or consent that they are unable to sign.
Able
If
to
it's
sign.
the case that maybe the children were not born here, and so yes, they came and they have indefinite leave to enter because of me, then they will go ahead and say, okay, because maybe the other parent is a parent out living abroad,
Yeah.
um, of course, you will not know their whereabouts, and then they can go on and proceed. Where the child was born in the UK and maybe both parents are listed on the birth certificate, this child maybe has been able to um, go on the 10-year route to get indefinite leave to remain, and you're still saying that this parent cannot provide consent. That can be a bit stressful for yourself, because then they will want to know why can't the other parent provide consent, and then they will ask for further evidence. Some parents may be able to do an affidavit to swear that they have been the sole parent of this child throughout
Child, yeah.
their life, and then there are some parents obviously who may have child arrangement orders in place, or some sort of court order in place to show that they are the main, should I say, parents looking after this child. But
Mhm.
when it comes to giving parental consent, they make it an obligation for both parents to consent to the registration. But where in cases, for instance, where the child came from abroad and the other parent hasn't played any role, you can go ahead and say that is the case, and that is why you're unfortunate. It's unfortunate that you can't provide the other parent's consent. But if there is any evidence that this other parent is here because he's listed on their child's birth certificate, and maybe he's actually made some, should I say, reports to the Home Office before and other things, they might want to find out why the other parent cannot provide consent. And that is where a court order will be necessary, or a statutory declaration to prove that you are the sole parent may be necessary as well. So, in terms of consent, where you can get consent, you might as well get the consent of the other parent.
So if the child's birth certificate has only the mother's name on there,
Mm.
does that mean that during the application, it's just the mother who is expected to sign the consent form, or the
If
Home Office assumes that maybe at the point where the child was registered, maybe the dad was nowhere to be found, but later on in the child's life, the dad resurfaced, but on the birth certificate, it only has the mother's name. How does it work?
I mean, when it comes to making the application, even if the father resurfaced sometime in the child's life,
Mm,
they have no evidence of that.
yes,
So the only
yeah,
evidence they have is the birth certificate. So if
right.
the child's father is not named on the birth certificate, they will just go by the evidence they have. And so if it's just the mother on there, then they
Mm,
expect just the mother to provide
mm,
consent. And if
mm.
the father is not available, then we are saying that because the mother has been solely responsible for the children, she's the only person that can provide consent. Yes.
Okay. All right. Okay. On this note, I think Laura Eunice would need a glass of water. She's been struggling with her throat. So let's please take a commercial break. We'll be right back. Don't go anywhere.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.
Welcome back. This is Hanging Now with BWF Solicitors. I'm your host, Vicky Newton, and today I have lawyer Eunice Champon with me. She's also a solicitor at BWF Solicitors, and we have been talking about children who have indefinite leave to remain but want to register to be British. Lawyer Eunice took us through, the Nationality Act requirements. We also answered some few questions. Please send in your questions, and Lawyer Eunice is here to answer your questions. This is a free legal education. Lawyer Eunice,
Hi.
parent is watching us and has a teenage child. The reason why I'm saying this is I noticed there's been a lot of issues going around when teenagers go, probably are found at the wrong place at the wrong time, and it turns out to be a police issue. I've noticed that when it's a very serious issue, they can strip you of your British nationality. But a lot of our, our teenagers are not taking this very seriously. They feel because they were born here, they've got a British passport, and that's it. So they can just go about life doing whatever they want to do irresponsibly. We as parents, what advice you have for us to instill in our children that whatever decision they make or what kind of company they would like to keep, and they would have to be very careful because having a British citizen status can be taken away from you if you fall at the wrong side of the law.
When it comes to our children, as you say, a lot of the time, I know that sometimes it might even be the fact that they have been seen at the wrong place at the wrong time. And there will be situations where they may even be charged and convicted of an offense where they will have to be in, I think they call it young offenders, juvenile detention centers. And then there's also those that are over the age of 18 who would actually go to the actual prison because the young offenders detention centers are for those under 17. And so if they have usually been convicted of such an offense, then the likelihood of them being deprived of of their citizenship is mainly to do with those that may have made the application, and at the time, for instance, committed an offense and didn't say that they had committed an offense at the time that they were making their application, for instance.
Mm, mm,
Um, there will be situations where the offense can be so serious, such as committing a terrorist act, and then they can say that, do you know what, because the offense you have committed is so serious, and we believe that you are somebody who has committed such an offense, we would therefore deprive you of this citizenship, because your character is not something that we feel is a good conduct in a society like ours. And so, if your character is such that they feel you're not compliant with the British laws, or you're not compliant with our um, way of life and the way that we do things,
mm,
then this is something that they can easily strip you of. So, under Section 40 of our British Nationality Act, you have offences where, for instance, you haven't disclosed information, or, for instance, you have given information which you clearly know to be false in your
mm,
application for British citizenship, or for one reason or the other, you made you have committed an offense which you did not mention, and later on it's found out that you are somebody who has committed so and so offense. um you have people who, as I mentioned, may have committed um, terrorist offenses, or offenses where they have been imprisoned for
mm,
12 months or more, and they feel that that in itself is such a serious offense that they would have to deprive that person of their citizenship. And so, where that is the case, then you would have to be able to rebut the stance that this is something that you didn't know was required, for instance, when you were filling in the application. But
mm,
where you have gotten your citizenship and you have gone on to commit serious offenses, like we can see in the news in regards to Shemaya Begum and other young people that have committed terrorist offenses, the Home Office has said, well, you have another nationality.
mm,
You are not necessarily just British. Your parents are from Bangladesh, or your parents are from whichever country. You can have that citizenship because the law in that country may apply for you to then get, let's say, Bangladeshi citizenship. So
mm.
if that is the case, then you can revert to that citizenship rather than have the citizenship that we have given to you, which you have
Okay.
taken for granted. And so
Mm,
they can strip you and then say that you can revert to your other citizenship because of the fact that maybe the other country that your parents are from will allow you to have their citizenship. So I know that in a country like Ghana, for instance, when your parents are Ghanaian, and if you have any grandparents that are Ghanaian, you as a young person can also be eligible for Ghanaian citizenship. So, if, for instance, such a person was stripped of their citizenship, they would say to you, well, you can easily revert to your other citizenship and there shouldn't be any issue whatsoever. The only
mm.
issue is when the person is stateless because they have no other citizenship to
That was what I
be
was going
seen
to
by.
say. Yes,
Yeah,
yes, yes.
that is when
Mm,
there is an issue. So when
mm,
somebody has been declared stateless, and then
mhm.
you're saying to the government that, well, now that you've stripped me, I haven't got a nationality, so I haven't
Reality.
got an identity, basically. So even though I have a name, I haven't got a nationality to go by. And so then
Mm,
they have to reassess how they can, of course, um, say that you can now be known as a British citizen. And it's
Mm.
a very difficult decision because you can't let someone be stateless, and that will basically deprive them from traveling anywhere or from going
Exactly.
anywhere. And so
Exactly. Yeah.
it's a decision that the Home Office doesn't take lightly, and they definitely try their best to look into these things. And that's why a
Mm.
lot of people say that this is something that affects the ethnic minorities, because somebody who is Caucasian would not have this issue because
Yes.
their ancestors and everybody else is British. But if
British. Yeah.
you have somebody who is from an ethnic minority, you're basically saying that you can easily strip that person because that person
Mhm.
has
Yeah.
another nationality which they can fall back on. Um, it's important that as parents, we make sure that we are guiding our children in the right way. I know that they will fall into wrong hands sometimes, but as much as possible, we should also be involved in their lives. There are some parents that don't know anything about their children, and it's shameful. I'm sorry, but if you're a
Yeah, but
parent,
Lawyer Eunice, you are Eunice. You are working two, three jobs.
but it's so
Lawyer
wrong.
Eunice, it's not easy.
It's so wrong. I know it's not easy, but in the country that we are living in, unfortunately, the government cannot train your children. The school
Yes.
cannot train your
Yeah.
children.
Yeah.
You, as a parent, has to train your child, and you cannot expect government agencies to bring up your child.
Your
There are some
child.
people or some parents that I know that will tell you that they are not able to discipline their children because they were given birth to in the UK. I said, what? Just because your
Wow.
child was born in the UK, you cannot discipline the child? It doesn't make any sense to me
Wow.
whatsoever. I'm not saying that we should be hitting our children anyhow,
No. No.
but
No.
you have to know how to discipline the child and
Hmm.
correct the child in the right way. I mean, there
Yeah.
are some parents who will just hit the child anyhow, and they will not even explain to the child what they've done
Explain to
wrong,
the child. Yeah. It's true.
and how they should be corrected. That's something that we lack, and I think when we look at our children, we should know how they relate to us and how they relate to people around them. Because they communicate a lot, we have to be able to communicate back to them. If the child is doing something that is obviously wrong, you as a parent should be firm and be able to tell them what they're doing is wrong and you need to correct them. If they
Hmm.
need time out or if they need to be disciplined, you need to be able to discipline that child so that they understand that what they did was wrong and you will not tolerate that behavior. But you can't say that because the child was born here, so you are not going to discipline the child. That is so wrong. But if
Hmm.
we are able to discipline the children, if we are able to correct them, when they get to a certain point and they are even in danger and they know that the company they are with is not right, they can at one point message you and say, Mom or Dad, um, I'm involved in something and I don't know what to do. I don't know how to get myself out of it. They will communicate back to you. But where you haven't given them that discipline, where they haven't had that correction, they will go into it and they will not even have that moral compass to say that, do you know what? What I'm doing is so wrong that I need to get myself out of it.
Hmm.
So it's important that we instill that discipline and we are able to correct them as much as possible. And then
Hmm.
hopefully, when they find themselves in these situations, they can also communicate back to us and let us know how best to help them. Yeah.
Wow. On that wonderful note, Laura Eunice, quickly give us a brief about what we've discussed so far. And for the benefit of those who would like to get your contact details, to contact you, we would like to have that as well. Laura Eunice.
Okay. So, as Vicky said, I am one of the solicitors at BWS Solicitors, and we are situated in London. So, our address is the fourth floor of Anna House, 214 to 218 Tottenham High Road, London, Our postcode is N154NP. So it's N154NP. We usually have face-to-face consultations, but if you would want a remote consultation, either by phone or Zoom, we can have that done for you. Our office number is 0208 493 7340. So 0208 493 7340. We are usually open from Monday to Friday, 9:30 a.m. to 6 p.m. And if you want to phone me out of office hours, you can call me on 075 35813910. So 075 35813910. I thank you all for joining us, and I wish you a very nice and lovely weekend.
Yes, Laura Eunice, thank you so much for taking time off to be with us, to educate us, to, guide us, and also give us advice. We very much appreciate it. Until then, we wish you all the best. Have a wonderful month. Happy Easter in advance. And stay blessed. Bye-bye.
Bye.
Based in London, we are a dynamic award-winning firm specializing in a range of legal services, including family law, matrimonial law, immigration, dispute resolution, Ghanaian customary and family law. At BWF, our solicitors are pleased to offer high-quality legal representation at competitive rates. Our senior partner, Bernardo Wusu, has over 29 years' experience as a lawyer in the UK. BWF solicitors provide independent and practical legal assistance for all kinds of family matters, such as childcare, contested and uncontested divorce, and injunctions for domestic violence. Our childcare and family team appreciate the issues facing you in this difficult time, which is why we offer confidential advice delivered in a sensitive manner. Our senior partner is an accredited member of the Law Society Family Law Accreditation Panel, which guarantees expert representation in all family and matrimonial cases. Are you seeking advice on immigration-related matters? At BWF Solicitors, our immigration team are experts in dealing with everything from general immigration to complex immigration work permits, arranging student visas, as well as entry clearance visas, family visas, and appeals. Our senior partner is an accredited member of the Law Society Immigration Accreditation Panel, which guarantees expert representation. Our office is open from 9:30 a.m. to 6 p.m. Monday to Friday, and on Saturdays by appointment only from 10 a.m. to 4 p.m. We are located at 4th floor Anna House, 214 to 218 Tottenham High Road, London, N15 4NP, just a short walk from Seven Sisters Underground. Our senior partner, Bernardo Wusu, is also a qualified barrister and a member of the Ghana Bar Association. He has acted as an expert in court cases involving aspects of Ghanaian law. He has also advised local authorities, the official solicitor's office, and other solicitors on the intricacies of Ghanaian law, and is a regular contributor on the radio and TV on matters concerning Ghanaian law.